This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are joined now by Todd Lutsky from the law firm of Cushing Dolan. The segment's called Ask Todd because, well, it's your chance to ask Todd your questions about your estate plan. Last week, I know we didn't quite get to everyone who had questions, so the incentive obviously is call early to make sure that your question gets answered. The studio line here is 888-205-2263, so that's the number to call if you have a question that you'd like to ask Todd. Again, that is 888-205-2263, and our phone lines are open now, so get calling to make sure that you can ask your question. I'll ask the first one. Mr. Lutsky, how are you?
I'm never better, and you?
Good. I met someone interesting yesterday.
Uh-oh.
He had told me that he had started investing in stocks, specifically beef, chicken, and vegetable stocks.
Oh, food stocks.
Well, it sounded like he was trying to be a billionaire.
Well, did that work for him okay?
Hard to say. We'll see how it works out.
How that works out.
Want to talk to you a little bit about naming beneficiaries.
Yeah.
And specifically retirement accounts. Someone has an IRA or a 401k or 403b, different types of retirement accounts. What's the lay of the land these days in terms of how to coordinate your estate plan with who you're naming as beneficiaries on those retirement accounts?
Yeah, so retirement accounts with the the advent there of the Secure Act and the Secure Act 2.0, which I know we've all talked about many times, it makes it difficult to figure out how to fit an IRA asset into your estate plan. So let's run through a couple of examples. So, first and foremost, obviously naming the spouse is still the best way to go from an income tax and an estate planning standpoint. The beneficiary next, let's say children, if you want to name children as the beneficiaries. Certainly listing them on your IRA is fine. They will likely take it out over 10 years and have no real creditor protection, no real estate planning benefits, but they'll get to take it out over 10 years. That's what the Secure Act calls for. Well, if you have a trust in place and you've done your estate planning, the question becomes, and by the way, whether it's a revocable trust or not, doesn't matter for an IRA, because once you die, the IRA is the trust is irrevocable anyway. So after you die, the designated beneficiary on the IRA could be your trust if your trust is designed to hold an IRA. So you got to make sure it's designed right. It's called a look-through trust if you create it that way. But you could make the beneficiary of your IRA the trust, and you would do that really only if you have your trust designed in a way to protect assets from the assets that are already in there. Remember, all your non-IRA assets are in your trust. If that trust says, leave things equally to my children and pay it out, well, then I probably don't need to name the designated beneficiary of my IRA the trust. I can just list my kids and they'll pay it out. But if I'm going to be leaving assets in a trust that say are creditor protected, are protecting it from future divorces of the children, trying to, get assets to a generation below without paying any taxes at one generation, skipping taxation at a generational level, all good reasons. Well, then I might make the designated beneficiary of my IRA the trust to get those same benefits on those dollars. And another reason I might not is if I've got a large portion of my assets that are protected from the creditors through my trust already, and the IRA is not overly large, well, then it's okay maybe to leave that directly to the kids. So I think it comes down to how you want to leave your assets to your kids from your trust. The lion's share of your assets determines whether or not you might name the trust as a designated beneficiary as well.
We are in the middle of Ask Todd with Todd Lutsky. If you have a question about your estate plan that you'd like to ask Todd, this is your chance. We still got a little bit more space, so if you have a question, the number to call is 888-205-2263. 888-205-2263. Again, it's 888-205-2263 to ask Todd Lutsky your estate planning question. First up, let's go to Michael in Weymouth. Michael, you're on with Todd Lutsky.
Hi, Todd.
Hello.
Hi. I'm going to be 71 in May, and I have a 19-year-old son.
Mm-hmm. Are you single?
Yes.
Okay.
And I feel that it's time to do something.
Okay.
I have a house paid for.
All right.
All right. Not tons of money.
So the house is the primary asset.
It is.
What's it worth?
When you do a trust, you put bank accounts and stuff in there also.
So the answer is we're to find out what kind of trust first of all, but probably the answer is yes.
Yeah.
To that, what would you say the house is worth?
$800.
And it's paid off, so that's good.
Yep.
What would you say if you added up all your other banks, investments, and so forth? What are you looking at in terms of other non-real estate assets?
Let me see.
Just a rough number.
About $100,000.
So it's really all about the house, which is
Yeah.
perfectly fine. There's many folks that do estate planning that are worried just about a house. And in this case, the 19-year-old is your only child?
Yep.
Okay. So I would suggest in your case that probably that looking at your age and your family dynamics, that avoiding, you don't have a tax problem, so you don't have to worry about federal tax. You don't have to worry about death tax in Massachusetts. You're under the exemptions, which is good. But you would need to maybe avoid probate, I would think, and protect assets perhaps from the cost of long-term care. I would think that would be another important piece for you, with those two items on the list.
That's the main
Okay.
main ingredient. Yep.
Yeah, and since your son is only 19, we might want to figure out how best to leave it to him as well.
Right.
So the irrevocable trusts should get the house. So we would deed the house in. I'd probably leave your bank accounts outside the trust the way they are now. But in order to avoid probate, I probably would at least suggest that you make a designated beneficiary on the account, or if it's a bank account, they sometimes call it a transfer on death account. And that way the asset will at least get to your son directly without avoiding probate. But the house, I don't know what his status is in terms of, he's young, first of all, so I don't know that I'd want him just to own the house outright. I might want to hold the house in trust and provide, if there's money, if you want, you can put your money in to help pay for maintenance and upkeep until he gets going, but at least have it in trust for him and hold it in trust for him as long as you feel appropriate to do that. And the big reason we're doing it, though, is to put the house in the trust so that in case you get sick and go into a nursing home, that they don't, you don't lose the house. That's the biggest asset you want to leave your son. Even if he sells it, takes the money, and uses that to get on with his life, that's still a very good asset to leave. So I would say that that's the important piece of the estate planning here for you. Hope that helps a little. And at the end of the day, folks, this is really all about how you leave assets to your family. I mean, everybody's got beneficiaries, and how you get your assets to them might be most important to you. We're doing a new guide called just that, how to leave assets to beneficiaries. In this case, it was just one idea of protecting it so it gets there. But for a lot of us, it's once it gets there, how should they get it? Are we worried about divorces? Are we worried about joint accounts? Are we worried about second marriages? Are we worried about skipping generation tax issues? Folks, call and get the guide. It's one of my favorite because everybody has beneficiaries. 866-848-5699, or go to our website, legalexchangeshow.com. You can download it there. Again, 866-848-5699 or legalexchangeshow.com.
We got another call for you, Mr. Lutsky. Stephen in Worcester. What's your question for Todd?
Yeah, I got a third of my father's vacation home,
Okay.
and just wondering whether I should. I'm thinking of giving it to my son.
Mm-hmm.
Just wondering whether I should bother or just keep it till I go until I die.
So is that you have other assets other than your vacation home? I'm guessing you have like your own home, or do you have other?
Oh yeah, I have my own home.
Are you married?
And yeah, married.
And you have just the one son?
Well, I have another son, but he's challenged, so he can't really get anything.
Well,
I guess I could put into his trust, but.
So I got you've opened up a lot of issues for not just you perhaps, but for a lot of other people listening as well. So let me at least address what you've given me so far. So one, you've got a home, you've got a 1/3 interest in a vacation home. You've probably got your own other dollars, you and your wife, whatever those are. But most importantly, it sounds like you have 2 kids. One who, when you say challenged, I'll just use the word maybe special needs of some sort. Yeah. And so. Wow, let's think about how we leave these assets. So first and foremost, probably a trust is in order, maybe 2. If you're over $1 million, you might need 2 because of the estate tax implications. So from an estate planning standpoint for you, I would suggest at least a revocable joint trust if you're going to do non-nursing home planning. If you're concerned about protecting the assets from the nursing home to ensure these assets are available for your son or for your family in general, then an irrevocable Medicaid trust might be in order. I'd throw the houses in, your 1/3 interest. I probably would stay away from giving it to my son now. Giving it to your son now has problems because if you do, you have lost control over it. You've exposed it to his creditors. It's subject to his estate tax, his divorces, and more importantly, you're going to give him whatever gain is built into that property. So when you give away real estate while you're living, you generally need to remember that if there has been a gain built into that property, you're giving him that gain and you're giving him that built-in capital gains tax liability. Whereas if you die owning it through these trusts, you get a step up in basis at death, eliminating the built-in gain. So that can be a huge win for people going, for the beneficiaries. Now, having said that, I'm going to suggest that once your trust is funded the way you want it with your assets and you pass, folks, for all of you out there who have special needs children, we don't have to disinherit them if we don't want to, right? You can set up 2 buckets inside your trust, 1 for each child. You can make sure that the property located at your vacation land address goes to that particular son's share that you want him to get it. So at least they can feel good that they're getting it. And then you can divide everything else. And the child that's special needs, you put language in there with sole discretionary distribution language given to the other trustee. Obviously, you wouldn't have a special needs child serve as trustee, but you could give them the power to have another child to have the trustee power over that child and make distributions to them so they can have a better life, but they don't own it. So if they don't own it, not only is it not subject to their creditors, they can maintain any governmental benefits they would get. And folks, that's exactly what we talk about with these guides. Learn how to give your assets to your beneficiaries. 866-848-5699 or go to legalexchangeshow.com. You can download it there. I hope that was helpful.
Mr. Lutsky, thank you for your time today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing and Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com.